Добрий день, шановні колеги. Розпочинаємо.
Good afternoon, dear colleagues. We start our next event as the universal mechanisms of protection of human rights in Crimea results and prospects of filing 34 complaints to international conventions. Our guests are Eskender Bariev, chairman of the Crimean Tatar Resource Center, member of the Mejlis of the Crimean Tatar people. Good afternoon, dear ladies and gentlemen. Thank you. Today, we would like to provide information about the importance of work concerning protection of rights of people in the occupied territory, the work with the universal mechanisms to protect human rights. The matter is, I would like to provide information how these violations may be documented, those violations that are now ongoing in occupied Crimea, and to focus on the importance of universal mechanisms. From the start of occupation by Russia in 2014, in Crimea there are continuous violations. People are their rights are violated, and there are political persecutions and limitation of rights, and also cases are started against Ukrainian activists and representatives of Crimean and Tatar people. And daily in Crimea, many violations happen, people disappear, there are searches, illegal searches, detentions, arrests, and they are recorded by our center and other human rights organizations, and also due active work of journalists, we are able to get such important information. I would like to mention three important aspects concerning violations in Crimea. First, this is unfair justice, unfair court. We face the situation when they continue the detention of people who are now in prison of FSB, and also judges take illegal decisions. Second one is pressure by law enforcement structures on people, and this is systemic searches, systemic detentions, and also warrants. So in this way, they provide the physical and psychological pressure. And we recorded such instances. And in detention or during detention, they forced people physically. And also xenophobia against Crimean Tatars and the Ukrainians by Russians, including so-called self-defense units. So the changes they are trying to introduce into the history of modern Crimea, and also constant incitement of hatred, and also limitations of rights of people on education in their native language. The most important area is the collection of evidence that will be the basis and the basis of violations of human rights by occupation power in Crimea. This should be done in accordance with the Criminal Procedural Code of Ukraine, and the majority of witnesses live in the Crimea and Sevastopol, and law enforcement structures of Ukraine, such as Prosecutor's Office of Crimea and National Police of Crimea, they do not have possibility to carry out pre-trial investigations and to carry out the interviews with witnesses, and this makes the work of our law enforcers more difficult. And once again, I would like to repeat, the journalists and human rights defenders, they play an important role in this because they gather this important information. Also, according to legislation of Ukraine, there are three ways how to get information. First, this is the interview in the territory of Ukraine that is controlled by the government. Also, a video interview and then provision of these materials. And this video footage will be provided as an evidence to law enforcement bodies, and also the work of the lawyer that in accordance with Article 20 of the law of Ukraine on advocacy and advocate activity, they may gather this evidence and then provide them to the judiciary body. As of today, the most realistic ways is to bring witnesses. This is realistic but really difficult, and also video registration of provision of evidence and further use of these materials by the competent bodies of Ukraine. The source of information are the witnesses of repressions and their relatives, volunteers, journalists, bloggers, streamers, civil rights defenders and advocates who have Russian license and advocates who have Ukrainian license. Also the types of documentation of violations in Crimea, journalist investigations, journalist content that is usually used, and the content we get from the bloggers and streamers. They play important role, and they have important function, and they are evidence materials for in the collection of the materials, also documenting by activists, preparation of claims to international courts, and preparation of complaints and applications to convention bodies, and also cooperation with competent bodies of Ukraine and provision of information about human rights violations on occupied Crimea. Also difficulties in documenting. In practice, we see that the victims of repressions fear to contact volunteers, activists, and law enforcers, and so we do not have a clear understanding of what happened. Then lack of protection of victims, and also difficulty to bring these people for provision of evidence to competent pre-trial bodies, also lack of legal awareness of people concerning documents and the getting of documents. And we face the situation when we try to collect evidence. We saw that many victims, they do not have, they lack some documents, and also lack of qualified advocates and human rights defenders. And several organizations, together with our organization, we try to teach some lawyers, and even those who do not have proper education, they may really get better understanding of the situation, and they know how to collect evidence in order that further on more qualified lawyers be able to file these complaints or applications. Also persecutions of lawyers, human rights activists, and streamers by occupation authorities. People live in fear, and there is a group of advocates who, despite arrests and warnings, they continue to do their job. Also lack of experience in the work with international courts and convention organs of UNO. Also one important fact, lawyers and human rights defenders in the occupied territory, they just physically cannot prepare these documents for the international bodies, these complaints, communications, because it takes a lot of time, and they are more focused on participation in those actions, and they try to document violations made by FSB, and they try to carry out the processes in a proper way. So also there is lack of experience in the work with the international courts and convention bodies of UNO. So about the importance of preparation of complaints and reports to convention bodies, on the example of International Court. International Court of UN, Article 97 of the order, decided to take into account the report of UNCHCR, and this is about Mejlis, that the prohibition of Mejlis as a self-governance body, it rejects the right of people of Tatar people, and also International Court decided to take into account the report of UNCHCR concerning the situation with human rights, and it shows that nobody can replace Crimean Mejlis and Kurultai, because these are the most important bodies for Crimean Tatars. That's why Mejlis is considered as the most important body for Crimean Tatar, and that it really differs from other unions and associations of Crimean Tatar. Also, International Court in Article 98 states that the prohibition of Mejlis may lead to bad consequences, and it can violate the Convention on Racial Discrimination of 1965. So the norm of the order of the International Court of UNO directly rejects the arguments of the decision of the Supreme Court of the Republic of Crimea and the decision of the Appeal Court of Russian Federation. And now I would like to tell you about the convention bodies of UNO, and we are trying to work with all these bodies, but here you may see some procedures, and of course it is really important to have really good professionals. In this way, we will be able to use these mechanisms more efficiently. So the main bodies, the Council on Human Rights, also there are 10 bodies that are the Committee on Human Rights, Committee on Social, Economic and Cultural Rights, Committee on Liquidation of Racial Discrimination, Committee Against Discrimination and Torture, and the Committee on Forceful Disappearance. And also I would like to note the next institution as the Special Rapporteurs. So when we apply to these bodies, so here we do not have necessity to go through appeal process or through cassation process. In this way, we are able to constantly and systemically file collected documents that can be used further on. And also convention organs, and here complaints of to Special Rapporteur, complaints to UNCHCR, HR, and to complain to independent expert, and complain to Special Rapporteur. And we used this opportunity several times. And we should pay attention to the fact that when we file a complaint to the European Court on Human Rights, so you should undergo appeal instance. And when we go, and when we are speaking about these bodies, here we should not go through this procedure, and this simplifies the work in this area. So in the period of our work, in the period of the last 10 months, in 10 months of this year, we submitted 34 complaints, and we as a center helped to prepare these documents, 8 reports to the Bureau on Democratic Institutions and Human Rights. So 8 reports were provided to the Bureau on Democratic Institutions of OSCE, 7 applications to European Court on Human Rights. So in this period, taking into account that it is necessary to undergo internal procedures, 7 complaints to European Committee on torture and inhumane treatment, and 5 individual communications to special procedures of the Council of Human Rights, and also about the proper housing and proper level of living and non-discrimination in this. Also one on human rights, and also 2 complaints to the Committee on Human Rights. So these 2 complaints, there were a lot of problems, because here we should have gone through cassation, and in practice we faced the problem when there is delay and we plan to carry out some processes in some time. So physically, sometimes we are not able to do it in time because of the deadlines. Also, one to the OSCE on the freedom of the media, 1 forceful disappearance report to Special Rapporteur on indigenous people, and 1 to the indigenous report to. So our lawyers, our activists and our lawyers, they were able to carry out this work in 10 months of 2018. In order to increase the competence, we carried out in this period 5 seminars, and advocates, lawyers, and activists participated, including those from the occupied territories. And we also didn't tell about this before because of the security reasons. And this program was supported by Freedom House and supported by the cooperation unit of the Embassy of Lithuania. So before we prepared such materials, and I wrote these abstracts that were mentioned in the decision of the International Court, including the case of Mejlis, and we submitted the application taking into account new evidence, and we got new evidence, and we submitted about 16 cases to the International Court at different levels, from the members of Mejlis, from the members of local and regional Mejlises, and from local Mejlis, and from the head of the CEC of Kurultai. And in this way we saw the systemic character that Mejlis and Kurultai, this is not just some NGO, this is a systemic body that has representation functions and is responsible for the representation of Crimean Tatar people, and Russian Federation using the court in Crimea and using the court in Russian Federation banned this organization as extremist one. And we hope that all this work that was done and the statistics I provided, that it will be reflected in the reports and of the representatives of these bodies, and correspondingly this will provide opportunity to us to use this materials in the court hearings against aggressor against Russian Federation. And I hope that this work will bring serious results, and we want to continue in this direction, and we would like to train more people and to submit more complaints and applications, and the more we communicate with the victims and the defenders, the more results we will achieve. I'm ready for questions if you have them. RTR channel, you said that in 10 months you submitted 38 cases. No, 34 cases. And can you compare it with the previous periods? And also about the prohibition of Mejlis filing. Whether these materials were used in courts during hearings, and what term is needed for these materials to be used during court hearings. So in 10 months, we were able to submit 34 complaints and communications, and each body has its specific procedure. If we are speaking about the European Court on Human Rights, this can take several years or maybe several tens of years. And I would like to say that we got special numbers, special cards, and it says that this case is taken for consideration, and we have hope that they will be considered and this will yield result. About special rapporteurs, we, for example, the special rapporteur on the indigenous people's rights, we provided the report, but not only the report, but also we met personally, and there was a representative of the mission of Ukraine in Geneva to work with international organizations. So we invited the special rapporteur officially, and we hope that he will come to Ukraine and to have this meeting with the Crimean Tatar people that may come from the territory that is occupied to Ukraine to have this meeting. So also, after this work is done, we will be able to get results, for example, in a year or during the year after filing. So our task is to provide a content analysis of those reports in order to see at least a line that special rapporteur, for example, took into account our complaints and our declarations. And about actions, what was done last year. Last year, we mainly dealt with the issues of Mejlis, and thanks to the fact that we collected some materials and we were trying to use newly established circumstances, and we submitted a so-called court, occupation court, in order that they considered taking into account a decision, intermediary decision, by International Court of UNO. Of course, I personally submitted it, and there was a complaint. I provided the complaint, and we got the response that we needed to provide a translation into Russian, the translation of the order. But according to the procedure, we wrote to the Ministry of the Foreign Affairs of Russian Federation and the Ministry of Justice of Russian Federation that they should have translated into the Russian place it on their sites, but they didn't do it, and the decisions should be in French and English, but they didn't answer our letters, and when we translated it into official Ukrainian and we submitted it, they didn't take it for consideration because translation was in Ukrainian. Once again, if we refer to constitution of so-called Crimean Republic, Ukrainian language is official there, but the court considered that it is not needed, or and it didn't take it into consideration, this copy of the order in Ukrainian. That's why we provided these documents, and we sent it to the International Court, and the Ministry of Foreign Affairs provided a new memorandum in July, and all these documents were reflected in the memorandum, and this provides further evidence to the fact that Russian Federation, or the courts of Russian Federation, they discriminate us because they didn't consider this document in Ukrainian, and they violated the decision of International Court. And concerning the events yesterday in the Azov Sea, does it provide a new focus for raising the issue of human rights protection in Crimea? So some people from there, they're brought to some hospital, and defenders and our diplomats cannot reach these people. So will the situation deteriorate, and what will be the consequences for Russia because they committed these violations under their own flag? Before they were acting without insignia, and now they did it openly. How can it influence the situation? So you answered your own question. So yesterday, for the first time, the Russian Federation, under the flags of Russian Federation, they committed aggression and they attacked Ukrainian vessels. And in 2014, there were green men, and Russian Federation said that this is not their people. When they occupied Crimea and in the east of Ukraine, there were some militants, and they declared that they are not present there. But yesterday's crime that they committed, they violated UNO Charter and international maritime law, and the law of 2003 that this sea can be used both by Russian Federation and Ukraine equally. So we may follow the situation, and the Security Council of the United Nations will have a meeting, and also today there is a meeting of the Verkhovna Rada concerning the introduction of martial law. But the procedure is needed in order to draw attention to the fact that Russia commits military crime against Ukraine. And here, an important aspect is, if you pay attention to this, Russian Federation until today's morning, they didn't comment on anything. But now we see that they say that Ukraine provoked them. But yesterday they rammed our vessel, and they wanted to show that they didn't use arms, and they tried to stop provocateurs. And Ukraine should have proper procedures and to deal with these issues, and the situation around the sea, the Azov Sea. There was the declaration of the European Parliament. We know that in the arbitrary court there is a court hearing, and here there is work of our diplomats that is important, and our lawyers and human rights defenders. And we are really concerned about the conditions for our citizens. We do not know anything about them now, and also our ombudsman at the Verkhovna Rada and his colleagues, they try to contact their colleagues in Russian Federation, but they do not provide any information. There should be active work of all sectors, both state and civil society sector. They should work together. Today at night I watched CNN, and there was such a content that allegedly Ukrainian vessels provoked the situation, but this is a negative message, and we should record maximally this crime, and we should campaign in order to bring information to international community that Russian Federation continues aggression against Ukraine. And yesterday, when this information appeared, that they ram this vessel, there was no official declaration from the Ministry of Defense of Ukraine, and they said Russians provided information that they have irreversible proof that Ukrainian soldiers were trying to do this provocation. But this is all manipulation of Russia. So they knew that the target two light vessels will pass there. They knew about it. And when they came to the Kerch Strait, they informed once again about this trip, and they even returned. They even turned to return to the place of their deployment in Odessa. But this was done intentionally in order to show that Ukraine provokes the situation, and at the same time they try to stall the process. They want to show that the Azov Sea is the sea of Russian Federation, and here we should go back to the issue whether we should denounce this agreement or not. And here, in expert circles and in political circles, there were a lot of talks about this, but we see that Russian Federation gravely violate this treaty, and they believe that the Azov Sea, they believe that this is their internal sea, and they violate the treaty, and they do not allow Ukrainian vessels to go there. And about the activity, maybe it is connected that Poroshenko wanted to prepare the documents for denunciation of this treaty. Whether these facts are connected, I think that this is a complex of questions and actions, and I believe that the Russian Federation, they are in hysteria now, connected with the latest processes. When Russian Federation it loses control over Ukraine because of the religious area and those events that happened, they are really of great historic importance. And Russian diplomats, they have big losses. When the Third Committee of the UNO adopts a resolution, and in previous years, all official bodies, they also adopted Ukrainian position, and also there will be reinforcement of sanctions, and that's why Russian Federation, it tries to provoke some situations in order to start new discussion, and they want to have further negotiations, because we understand that Western world, they are not ready to fight Russia, and they try to negotiate with them. And why do they believe that this is their sea? Only because they can apply force. Because there was a division 60/40 to the benefit of Ukraine before. So now we see some hooliganism from the side of Russia, and they gravely violate the treaty about internal sea for two nations, and also those experts and politicians who declared that we need to denounce unilaterally this agreement. It would lead to the fact that we should consider the sea in percentage depending on the coastline. So these actions were committed against other CIS countries. I remember 1993 when in Karabakh they increased military actions, and there were issues of demarcation of the Caspian Sea area, and you may consider this as a sea or as a lake, and it is divided sectorally as a lake, and as a sea it is divided as a free sea, and the war increased, and they put more pressure, and otherwise there would be a lack of control on the drills from the side of the Azerbaijan. So this is the parallel thing as it is like in Azov Sea. So during all years of Ukrainian independence, unfortunately, our analysts and our politicians, they didn't come to proper conclusions. They didn't properly analyze the experience of other countries of the former Soviet Union, and so now we may see the result of this. And today we should work in cooperation, working groups, our scientists, because our scientists, they provide their recommendations, and state bodies do not often take their opinion into consideration, but they should cooperate more, and the state bodies should cooperate more. So this experience of Ukraine, this is the experience of getting real independence, establishing of the real state. We would like to thank our honorable speaker, and we end our briefing.